Senate will please come to order. It's my wonderful pleasure to welcome for today's devotional exercise on St. Patrick's Day, Reverend Mark Pitton of the Sharon Congregational Church. Welcome, Reverend.
I invite you into a moment of calm by intentionally breathing in and slowly breathing out. And may that calm open you to something holy. May we be in a spirit of prayer. All that is sacred and lovely, we confess that we feel the uncertainty of our times. Individually, each one here has family and friends, hopes and expectations, incomes and expenditures. All seem dimmed by the issues that become headlines and by the quieter issues of family. Each heart here goes out to the most affected, even as it affects us too. Each seeks to do what they can and may to move through these uncertain times. Grant that personal anxiety eases and allow a light for their path to times that will certainly be better. We would thank you, Spirit of compassion, that the people here have also taken a burden to see our state through these uncertain times. It must be exhausting responding to a pandemic and those who will not deal with it, shooting wars and cultural wars, prices and incomes when only one seems to increase, sourcing of fuel, and the various inequities that challenge our belief that all are created equal. And then these people have to do the usual work of our Senate. Bills becoming laws, taxation, ethics, what is justice for young adults, and how to deal with disagreements about them without them becoming political tools. How hard it must be to see clearly what will be the most help and add the least complication. How hard it must be to see a path and convince others to travel a path that they do not see clearly. How hard their job is will never be comprehended. Spirit of gentleness, let a wind blow over these good people as they try to do good. Encourage them with laughter, support them with real care about their lives, relax them during the boring bits, amuse them with their own idiosyncrasies, and bring to light the small and hidden successes they have. Bring insight or patience to their deliberations, gift an understanding ear or a compelling argument to their debates. Both would be ideal. And let the wind blow the minor annoyances over the border to another unnamed state. And when this day is done, allow them a night of rest, deep sleep, and pleasant dreams. Keep them safe until they are in family homes and arms. And may they remember that breathing in and breathing out allows them to touch and be touched by holiness. Amen.
Thank you, Reverend. I'll kindly invite senators to stand for the pledge.
I pledge allegiance to the flag of the United States of America and to the republic which stands one nation under God, indivisible, with liberty and justice for all.
Are there any announcements this morning? If we do have Of bills for referral under Rule 31. S-195, an act relating to the certification of mental health peer support specialists being on the calendar for notice and carrying an appropriation or requiring an expenditure under Rule 31 is referred to the Committee on Appropriations. S-226, just to confirm, that was S-195. This is S-226. An act relating to expanding access to safe and affordable housing, being on the calendar for notice and carrying an appropriation or expenditure of funds under Rule 31 is referred to the Committee on Appropriations. I do believe we need a motion on S-281.
Thank you, Madam President. I move that the rules be suspended and that S-281, an act relating to hunting coyotes with dogs affecting the revenues of the state, be referred to the Committee on Finance pursuant to Rule 31.
The senator from Windham has moved the rules be suspended and S-281, an act relating to hunting coyotes with dogs affecting the revenues of the state, be referred to the Committee on Finance pursuant to Rule 31. Are you ready for the question? All those in favor, please say aye. Aye. Those opposed, nay. Ayes have it, and you've suspended the rules and referred S-281 to the Committee on Finance. We have a joint resolution, JRS 46, to take up at this time, a joint resolution relating to weekend adjournment. Please listen to the reading of the resolution.
JRS 46, joint resolution relating to weekend adjournment. Resolved by the Senate and House of Representatives to when the two houses adjourn on Friday, March 18, 2022, it be to meet again no later than Tuesday, March 22, 2022.
Now you've heard a reading of the resolution. The question is, shall the Senate adopt the resolution? Are you ready for the question? All those in favor, please say aye.
Aye.
Aye. Those opposed, nay. Ayes have it, and you've adopted JRS 46. This does bring us to the orders of the day. We have on the calendar for action H 444, an act relating to approval, of amendments to the charter of the City of Barry, read for the first time on May 20th. It was referred to the Committee on Government Operations, which reports it has considered the bill, recommends that the bill be amended as set forth on pages 1130 to 1132 of today's calendar, and that when so amended, the bill ought to pass. Please listen to the second reading of H 444.
H 444, an act relating to approval of amendments to the charter of the City of Barry.
The senator from Washington, Senator Polina, is recognized for the report of the Committee on Government Operations.
Thank you, Madam President. Please feel free to let me know if my mask is muffling my words to a great degree. H444 made several changes to the Barry City Charter. They're pretty straightforward, although one of them is a tad. Changes include allowing speed limits below 25 miles per hour on certain streets. And when it comes to bonding city officials, it removes the constable from the bonding of city officials and adds the inspector, and it repeals the position of chief constable in the city of Valley. Most notably, they chose to limit the flags the city can fly on poles. They limited it to the city flag, the state flag, the U.S. flag, and the POW/MIA flag. The other chamber removed this section from this bill. Your Government Operations Committee chose to add it back in. Not because we agree with it, but because the citizens of Barry voted to do it, and the committee generally believes that if citizens vote to change their charter, we should respect that vote whether we agree with it or not. The Legislative Council found this action does not violate First Amendment free speech rights. Courts have told us that flagpoles can be deemed a non-public forum, that government can designate open or closed public speech as long as it's equally closed or open to all. Recently, a constituent got in touch about wanting to fly the Ukrainian flag outside here on the flagpole in the State House. And they were told that they couldn't do that. They were told that the state can only fly the U.S. flag, the Vermont flag, and the POW/MIA flag. on state facilities. Flying another flag would take legislative action. So this mirrors the Barry situation. I want to be clear, I do not support this particular provision. If I lived in Barry City and I got to vote on it, I would have voted no. But Barry City held an election. As much as I may disagree with the outcomes of the vote, it's wrong to negate that vote, essentially overturning their election. This may be wrong at any time, but at this time when respect for democracy is at an all-time low, people are questioning the integrity of elections, not just here, but across the country. It really is no time to tell the people of Barry or anyone else that their vote didn't count simply because we don't like it. The voting committee was 3-2. We spent time with Legislative Counsel Tucker Anderson, Barry City Clerk Carol Dawes. We spoke to the Washington County delegation and to the Barry City delegation, and there was general agreement that this is the way to go. So we hope that you'll join us in approving this amendment to the charter change. Thank you.
The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Operations? Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay.
Nay.
Ayes appear to have it. The ayes do have it, and you propose to the House to amend the bill as recommended by the Committee on Government Operations. The question now is, shall the bill be read the third time? Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay.
Nay.
Ayes appear to have it. The ayes do have it, and you've ordered third reading of H 444. We have on the calendar for action S 140, an act relating to prohibiting civil arrest at courthouses. It was introduced on April 21st. It was referred to the Committee on Judiciary, which reports it has considered the bill and recommends that the bill be amended as appears on pages 1132 to 1133 of today's calendar, and that when so amended, the bill ought to pass. Thank you. Please listen to the second reading of S 140.
S 140, an act relating to prohibiting civil arrests at courthouses.
Senator from Chittenden, Senator Baruth is recognized for the report of the Committee on Judiciary.
Thank you, Madam President. If senators look on page 1132 of the calendar, you'll see the text that I'm referring to. May I speak to the strike all amendment?
You may.
The title of this is Prohibition on Civil Arrests at Courthouses, and I think that captures almost exactly what it does. It puts into statute a centuries-old prohibition on arresting people when they show up for a proceeding at a courthouse. Now, why do we do this now? Why do we need to do this? During the last administration, there was a change in policy, particularly at the immigration offices around the country, that they would use civil proceedings at courthouses to arrest people and then deport them. So this bill became generated about 3 years ago and has taken until now to reach the Senate floor. But again, for centuries, going back to England, there has been a prohibition on arresting people when they show up in good faith to answer a summons of a court. So I stress again, these are civil proceedings, not criminal proceedings. So if someone goes to a court for a criminal proceeding, they are not protected under this. But if they show up for a civil matter, including immigration matters, they are not to be arrested, and the bill has some teeth in terms of what can happen if they are wrongly arrested when they get there. And by the way, it would also protect them coming to the courthouse and leaving the courthouse. With that said, the next day, when their proceedings at the courthouse are done, they are not protected under this. And I think that points you to the real rationale for this. It is to defend individuals, it is to defend their families, but it is also to defend, in a larger sense, the court system itself. You can't have a robust court system if, when people respond in good faith to a summons from the court, they show up and they're arrested. So that's why England and then the colonies adopted these rules to protect the court system as much as anything. So if senators will look at the prohibition, any person or family or household member of the person who is attending a court proceeding in good faith as a party, juror, attorney, or witness shall be privileged from civil arrest while traveling to, entering, remaining at, or returning from the court proceeding. Then that's followed by a couple of exceptions, and those are crucial exceptions. It shall not apply to an arrest pursuant to a judicially issued warrant or court order, because there again, the legal system is being privileged. An arrest for contempt of the court where the proceeding is occurring. So if you show up in good faith and you commit contempt of court, you can still be addressed by the court. An arrest to maintain order or safety in the court where the proceeding is occurring. So those again are all things to defend not only the individual, but the robust judicial process that's underway. And then under remedies, you'll see that there are 3 remedies. A person who violates this section by knowingly and willfully executing or assisting with an arrest prohibited by subsection A shall be subject to civil contempt proceedings pursuant to Chapter 5 of this title and may be liable in a civil action. On the following page, these civil actions against a violator may be for damages, injunctive, equitable, or declaratory relief, punitive damages, reasonable costs, and attorney fees. And then the bill gives the Office of the Attorney General also the right to bring civil suit. I should point out that subsection 4 there immunizes the judiciary, or rather, immunity for the judiciary and any members or employees for actions taken to maintain order or safety in the courts. That's reiterating the provision on the previous page. Definition of civil arrest and household member and the effective. So it is not a complicated bill in terms of what's on the page, but I imagine that people might have questions about the interaction between federal law and state law. We did talk at some length with Ledge Counsel about this, and it boils down to, as Eric Fitzpatrick put it, the supremacy clause. So the U.S. Constitution gives supremacy to the federal government in many, many instances, but not all. And in this case, common law has protected the right to go to the courthouse and proceed with whatever matter you have there and leave the courthouse and be unmolested by the state. There is one case law on the books now, 2019, from the Southern District of New York, which found that, in this case, common law trumped the supremacy clause, so to speak, and you were not allowed to arrest a person on the way to the courthouse or at the courthouse. So with that said, I believe we're on firm footing in terms of case law, and I think this is something that Vermont should do to protect anyone on their way to the courthouse. But to speak clearly, we are talking mostly about documented who are in Vermont working on our farms, and to my mind, helping to save the dairy industry in Vermont. This allows them, if they're called by the court, to show up, conduct their business, and leave without fear of arrest or deportation. So with that, Madam President, I hope that the Senate will agree with the Senate Judiciary Committee, and I'm happy to answer questions.
The question is, shall the Senate amend the bill as recommended by the committee? Are you ready for the question? The senator from Addison is recognized.
Thank you, Madam President. May I inquire of the reporter of the bill?
You may.
Thank you. Just to make sure I understand the federal-state interaction, you started your report by saying that England had adopted this type of protection. The colonies adopted it as well. So does the federal government have this protection, or is it only in case law or common law?
It's in case law and common law. So common law and case law being pretty much the same thing.
Right, I learned that earlier this session. So there's no federal statutes that has this type of protection, Madam President?
I don't believe so, no.
Okay. But and for federal protection, the case law or the common law at the federal level that would impose this protection, would it cover like Border Patrol agents and Bureau of Tobacco, et cetera, and other beyond just federal law enforcement, with that sort of broader category of federal law enforcement?
Yes, I believe so. I think the Attorney General could bring suit in that way.
All right. Thank you, Madam President.
Are you ready for the question? And the question is, shall the Senate amend the bill as recommended by the Committee on Judiciary? All those in favor, please say aye. Aye. Those opposed, nay. The ayes have it, and you've amended the bill as recommended by the Committee on Judiciary. The question now is, shall the bill be read the third time? Are you ready for the question? All those in favor, please say aye. Aye. Those opposed, nay.
No.
Ayes appear to have it. The ayes do have it, and you've ordered third reading of S-103. We have on the calendar for action S-163, an act relating to state court jurisdiction for special immigrant juvenile status, which was introduced on January 4th. It was referred to the Committee on Judiciary, which reports it has considered the bill and recommends that the bill be amended as appears on pages 1133 to 1138 of today's calendar, and that when so amended, the bill ought to pass. Please listen to the second reading of S-163.
S-163, an act relating to state court jurisdiction for special immigrant juvenile status.
The senator from Windham, Senator White, is recognized for the report of the Committee on Judiciary.
Thank you, Madam President. And I would ask for your indulgence if I pause in my report at any point, because it seems when I breathe, my glasses fog up and I can't see my report. Some of the issues we address are headline grabbers. They get lots of media attention and get people all worked up. That is true whether or not they will have much of an impact on our residents, but they have good sound bites. Then there are those bills that get no attention, but have a significant impact on the lives that they affect. S-163 is one of those bills. I have received no emails about it, have seen no articles about it, and my guess is that most people don't have a clue what it is or how important it is. The bill addresses the vulnerability of non-citizen youth. Special immigration juvenile status is a status under the federal law that allows immigrant children who cannot reunify with their parents due to abuse, abandonment, or neglect. And let me remind us that abandonment is not necessarily a purposeful act by the parent, but could be because the parent has been deported. This status is unique among immigration remedies because a state court order is a prerequisite to filing for the petition with the U.S. Citizenship and Immigration Services. A child seeking this status must first ask a juvenile court in the state where the child is living to make certain findings. There are three. The individual is dependent on the state court. Second, the individual has been abused, neglected, or abandoned by one or both parents. And three, it is not in the individual's best interest to be returned to their country of origin. Federal regulations define juvenile court as a court located in the U.S. having jurisdiction under state law to make judicial determinations about the custody and care of juveniles. In Vermont, both the probate and family court share this jurisdiction and fall under this definition. The federal statute that provides this immigration status makes it available to all youth who are unmarried and under the age of 21. However, the first finding that the individual is dependent on the state court means that in Vermont, that is not available to any child as soon as they turn 18 because the court's jurisdiction ends at 18. As a result, non-citizen children in Vermont between the ages of 18 and 21 who would otherwise be eligible to petition the U.S. federal court for this status are unable to do so. The language in this bill essentially does two things. It removes specific references to special immigration juvenile status in the statute and clarifies that a non-citizen child can petition any state court in Vermont that has jurisdiction over that child in any type of proceeding to make these special findings. And it expands the jurisdiction of the state's guardianship provision for the limited purpose of allowing Vermont court to ensure special findings to non-citizen youth up to the age of 21. So S-163 begins on page 1133 of today's calendar. Section 1 amends the title and language throughout to strike reference to special immigration juvenile status and instead refers to vulnerable non-citizen children. Subsection A adds some definition. B clarifies which state courts have jurisdiction to review a petition for these findings. C sets forth the procedures for a petition for special findings by a vulnerable non-citizen child or a person interested in the welfare of that child. C2 offers, adds a, sorry, my glasses are steaming up, adds a headline for additional findings, and 3 requires the court to also consider health, safety, and welfare considerations that have impacted that child. 4 allows the court to extend a guardianship beyond 18 years of age up until 21 for the purposes of petitioning for findings if consent by the person is provided. Section D, subsection D, provides an alternative for serving notice if the child's parents' location is unknown or if the parents reside outside the country. And E requires the court to adjudicate these cases expeditiously when it is in the best interest of the child. F allows for voluntary reversal of the child to certain protective services. Let's see. And H liberally construes the section to its legislative intent, and I just removes the definition of court because it is moved to another section. Section 2 authorizes the Family Division of Superior Court to maintain jurisdiction over these children for the sole purpose of adjudicating the special findings and sets the process for petitioning the courts for the status. Section 3 is the effective date. This bill is particularly necessary in light of the vulnerability of this class of unaccompanied youth and their need for a custodial relationship with a responsible adult as they adjust to a new cultural context, language, and education system and recover from the trauma of abuse, neglect, or abandonment. Many newcomer non-citizen youth in Vermont without parents would benefit from having a guardianship relationship with a responsible adult. Such a guardianship, for example, may help a youth navigate education systems or Vermont that he or she is not familiar with and is in a different language. We heard from Erin Jacobson, the co-director of Community Justice Division in the Attorney General's Office, Will Lambeck from Migrant Justice, Jennifer Micah, General Counsel for the Department of Children and Families, Erica Radke, GCF, Jill Rudge, Vermont Law School Immigration Clinic, Rebecca Turner, Office of the Defender General, Rebecca Wasserman, Ledge Counsel, and Judge Thomas Zone, Chief Superior Judge. Our committee vote was 5-0-0, and we ask for your support. Thank you.
Question is, shall the Senate amend the bill as recommended by the Committee on Judiciary? Are you ready for the question? Senator from Chittenden is recognized.
Madam President, may I inquire of the presenter of the bill?
Okay.
Madam President, I'm just trying to better understand why the definition of a child up to the age of 21 years of age needs to include the provision that they are unmarried.
Because that, thank you, Madam President, that is the federal definition of who can apply for this special status. It has to be a child up to the age of 21 and unmarried.
Okay, thank you, Madam President.
Question is, shall the Senate amend the bill as recommended by the Committee on Judiciary? Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay. Ayes have it, and you've amended the bill as recommended by the Committee on Judiciary. The question now is, shall the bill be read the third time? Are you ready for the question? The senator from Windham is recognized.
Thank you, Madam President. As my seatmate said earlier, these types of bills often don't get a lot of attention, but they are incredibly important. And I just want to personally thank the entire Committee on Judiciary. We started this work about 4 years ago. We did the first part of this bill, which was dealing with special immigrant status for juveniles. And we ran out of runway because of the pandemic. We were not able to get the work done. And so this is an important technical correction that literally can help save the lives of children who are at risk here in Vermont. And so I appreciate the doggedness of the committee in getting this work done. And as my seatmate said, Aaron Jacobson, attorney who used to be at the immigrant clinic at Vermont Law School and now at the AG's office, was a critical piece of making sure this work got done. And I'm grateful, and I hope the Senate will stand with the work of the Judiciary Committee. Thank you.
Question is, shall the bill be read the third time? Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay.
No.
Ayes appear to have it. The ayes do have it, and you've ordered third reading of S 163. We now have on the calendar S 188, an act relating to regulating licensed cannabis cultivation as farming. Third reading was ordered on March 11th. Are there any amendments before third reading? Please listen to the third reading of S 188.
S 188, an act relating to regulating licensed small cannabis cultivation as farming.
The question now is, shall the bill pass? Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay. The ayes have it, and you've passed S 188. We have S 247 for third reading. Third reading was ordered on March 11th. S 247 is an act relating to prohibiting discrimination based on genetic information. Are there any amendments before third reading? Please listen to the third reading of S 247.
S 247, an act relating to prohibiting discrimination based on genetic information.
The question is, shall the bill pass? Are you ready for the question? All those in favor, please say aye.
Aye.
Those opposed, nay. The ayes have it, and you've passed S 247. We have on the calendar for action S 171, an act relating to adoption of a state code of ethics. It was introduced on January 4th. It was referred to the Committee on Government Operations, which report that has considered the bill and recommends that the bill be amended as appears on pages 1138 to 1148 of today's calendar, and that when so amended, the bill ought to pass. Please listen to the second reading of S 107.
S 171, an act relating to adoption of a state code of ethics.
The second reading. And I'm now pleased to recognize the senator from Washington, Senator Polina, for the report of the Committee on Government Operations.
Thank you, Madam President. I'm really glad to be able to bring this bill before the body today. it's been the subject of a lot of discussion in our committee over, it seems like the last couple of years, but certainly a lot this year, but they're working on it for longer than that. Basically, it's an important step forward for Vermont, is the way I would say it, because we're one of 5 states that has no code of ethics. There's nothing groundbreaking in this proposal at all. It's pretty basic and it's generally good, but it's not groundbreaking. It covers everyone, from the governor on down. And I want to mention, before we go through the provisions of the bill, the stickler that we dealt with over time in the committee, which was how to make sure that we integrated the General Assembly, the Judiciary, and and practicing attorneys into the provisions of the Code of Ethics. We decided after much debate and conversation that basically when it comes to the legislature, well, the Constitution tells us that only the legislature can regulate itself. That was the dilemma. You can't pass a code of ethics or anything that's going to tell the legislature what to do, because the legislature makes its own decisions and makes would sort of regulate its own people when they're engaged in core legislative activities, which means dealing with legislature, passing bills, working in committee, whatever the core legislative activities. And there's a list of those that I could share with you. Same thing with the judiciary. They have the Vermont Code of Judicial Conduct, which regards the course of action a political judicial officer would take when they're confronted with what may be a conflict of interest. And the same thing with licensed attorneys. They have Vermont rules of professional conduct regarding the actions of certain attorneys that may take precedent when confronted with conflict of interest or the appearance of conflict of interest that falls within their Vermont rules of professional conduct. In other words, if somebody's doing their work under their provisions of that would come under their code of professional conduct, that would trump the code of ethics when it comes time to consider regulation or of that person. Excuse me. After much conversation and debate, all the parties involved agreed that this was the way to go, that it would allow the code of ethics to move forward in a way that was comprehensive and effective, but would not interfere with the judicial code of ethics or the code of professional employment for the attorneys as well. So there are now 12 provisions in the bill. Let me first say that Code of Ethics applies to all elected or appointed officers, the General Assembly members, state employees, persons on state boards and commissions, and any state agents exercising state authority. When the action in question relates to core legislative functions or duties of members of the General Assembly, the relevant legislative rules and policies shall apply. That relates to the General Assembly. Narrow procedural exceptions apply in rare cases with licensed attorneys or judicial officers with conflict of interest that falls under both the Code of Ethics and the respective rules of professional conduct. Is follow the recusal procedure set forth by the relevant professional organizations. And that seems simple enough, but it took a lot of conversation and a lot of questioning and a lot of debate to get there. In terms of the 12 sections of the bill that relate to the Code of Ethics, the first is what we just talked about, recusal, disclosure for conflicts of interest. Public servants faced with a conflict or the appearance of a conflict shall publicly recuse themselves from the matter in question. A public recusal may be accomplished by informing the supervisor or other relevant party. If a public servant believes that they may proceed with the matter despite the conflict, they must disclose the conflict in writing in accordance with the policies and procedures set forth by the agency or entity governing the matter in question. Confidential information need not be disclosed. That's the first section of the Code of Ethics. The rest include no directing others to act unethically. Public servants cannot direct others to do what they cannot ethically do themselves. Number 3, no participation after recusal due to conflict. Once a public servant recuses because of a conflict, that recusal is full and complete. 4, avoiding the appearance of unethical conduct, which is self-explanatory. 5, no improper preferential treatment. Public servants should not show any favoritism or prejudice to anyone in carrying out state work, unless permitted by law and written party policy or rule. Number 6, no using state position for improper personal or financial gain. Number 7, no using state information for improper financial gain. Number 8, no using state resources for improper financial gain. Number 9, limitations on gifts to public servants. There's a list of gifts, of maximum gifts that could be permitted, which is in the bill, which we can go through if people find that they want to do that. Basically, it says things like ceremonial awards valued at less than $100 are okay. Gifts under $50 per occasion, not to exceed under $50 per year from a single source, et cetera. There's about 10 or 12 of those that we can go through. Number 10 is no making unauthorized commitments on behalf of the state. Public servants do not commit the state to name its resources unless authorized. Number 11, limitations on other public servants may not take outside jobs that conflict with state duties, and after leaving state service may not turn around and lobby their former agency or would switch up. Sorry, little mask issue. Okay.
All the time you need. We're good.
Limits on other employment. Public servants may not take outside jobs that conflict with state duties. And after leaving state service may not turn around and lobby their former agency or switch sides on the matter in which they are working. Number 12, must comply with all other relevant laws and rules not included in the code. The section that provides protections for whistleblowers, prohibits retaliation or intimidation against any public servant who submits a complaint to the Ethics Commission regarding unethical conduct. And the last one has to do with ethics training and education. If enacted, all public servants will be required to take training on the code of ethics within the first 120 days of the start of their public service, with additional training once every 3 years thereafter. Training is really important because the whole idea about the ethics code is not to like do gotcha and find people doing things wrong. It's to make sure that people know what's expected of them under a code of ethics so that they cooperate fully with the code of ethics and prevent anything from going wrong. The idea is not to like make people find it if we're out to get them. The other thing to keep in mind is that the Ethics Commission has no enforcement power at this point at all. We're basically talking about funneling complaints to existing agencies that might in fact be discovered and resolve them. What I would like to do is read, if I could, just a sentence to the office holders.
You may.
It says, quote, as you know, in our public service, we must account for and address issues such as conflicts of interest, preferential treatment, abuses of power, outside gifts, and protection for whistleblowers. A code of ethics embedded in Vermont law will provide public servants with direction and clarity on numerous issues they regularly face. We ask that you take the next legislative step and work with the Ethics Commission and others to establish a code of ethics for Vermont's public officials, public servants, in all 3 branches of government. Signed by Governor Phil Scott, Treasurer Beth Pierce, Doug Hoffer, Lieutenant Governor Dave Zuckerman, Secretary of State Jim Condos, and Attorney General E.J. Donovan. We spent a lot of time talking about this bill, as I mentioned. You heard from John Bloomer, who you're familiar with, Paul Burns, Executive Director. He was very helpful, by the way. John Campbell, Executive Director of the State Department of State Attorneys and Sheriffs. Harry Corzones, Executive Director of the Vermont Bar Association. Paul Erbaum, Vermont State Ethics Commission. Attorney Paul Gillis, Jason Grammett, past President, Council on Government Law, Ethics Law. Scott Griffiths, Interim State Court Administrator, Vermont Judiciary. Steve Howard, Executive Director of VSCA. Sid Saluzzi, lobbyist for VSCA. Thomas K. Jones, Ethics Enforcement Officer, Office of State Ethics. Mike Kennedy, Vermont Bar Council, the Vermont Judiciary. Ben Kingsley, Board Member, Campaign for Vermont. And Pat McDonald, President, Board of Directors. Both from Vermont. You heard, we also spent a lot of time working with Emma Abajoli, obviously our Legislative Council from the Legislative Council. To try to answer, I mean, I hope that it's clear that there are basically 12 rules that have to be abided by in the Code of Ethics, all of which are things we're familiar with, and all of which were things that would relate to everybody, from the governor on down to a snowplow driver. We've had instances lately where we've heard governors making decisions that were questionable at best. And when they decided to check it out to see if in fact what they were doing was under ethical questions or not, they were told, the governor was told, the then governor was told that there were no rules that he had to abide by in order to be in conflict, to be in conformity with ethics legislation. There were basically no ethics rules that he had to abide by. This would make sure that we have ethics rules that that everybody has to abide by, and without interfering with the daily operation of the legislature, the judicial, or practicing attorneys. The vote in committee was 5-0-0, and we hope you'll join us. It's been a long time coming, and we feel like we've worked really hard, thinking that we were going to come up with something pretty complicated. In the end, it turned out that what we were talking about was really pretty simple. Set of rules that people can logically understand and follow, make sure that we're all on the same page when it comes to discussing ethics in this body. Appreciate it, and we hope that you'll join us.
The question is, shall the Senate amend the bill as recommended by the Committee on Government Operations? A senator from Chittenden is recognized.
Madam President, may I ask a question of the presenter?
You may.
Madam President, I'm wondering, I'm looking on page 1145, subsection 10, training or education. It says a public servant may accept attendance to training. And I'm wondering, the legislature belongs to various groups and they hold meetings around the country, and sometimes they offer either subsidized travel and subsidized lodging or free travel or free lodging to that event. Is this the section that might cover that, or where should I look in the bill to whether that is still okay?
Well, it is okay up to a certain amount of dollar value. I would suggest that if that were the case, and that was a question for you or anybody else was raised, that you would ask the Ethics Commission for advisory on whether or not it was okay to do that.
Madam President, I thank the senator for that, but I would remain a little unclear. Is there someplace in the bill that marks out a dollar limit for accepting travel awards to conferences? Or would it, is the answer that you should go for an advisory opinion?
This senator from Wyndham is recognized.
Madam President, I request a short recess.
Oh.
Senator from Wyndham has requested a short